Hi everyone, this is Payal and today I'll discuss the recent case of Google wherein CCI, the Competition Commission of India, imposed a penalty on Google for its antitrust activities. This case relates to the Google Play services and Google Play billing system. Let us understand the brief facts of the case. So, the various app developers, in order to get access to the Play Store, requires to enter into an agreement with Google. Now, as a part of the agreement, various terms are imposed on the app developers to benefit the alliance services of Google, such as Google Play billing systems and Google's UPI app GPay. Okay. For this reason, an order was passed by CCI on 25th October 2022, imposing a penalty of whopping 936.44 crores on Google. The respondent were the various group companies of Google operating in India as well as its parent company Alphabet INC. And the informants were various consumers of Google such as the Match Group, Alliance of Digital India Foundation and others. Now when I do say that Google used such terms so as to benefit its GPBS, Google Play Billing System, let me explain what the terms were. So it required the app developers to mandatorily use GPBS for all the purchases of the apps as well as the in-app payments. Also, the service fee which was charged on usage of this payment processing system was quite high, 30%, and it was not negotiable. It was on the basis of take it or leave it policy. As regards the benefit to GPay is concerned, the mobile OS systems were required to mandatorily pre-install and prominently place GPay so that it can be used as a better alternative for UPI payments. Alright. Now, in case you want to go into the technicalities of the matter, let us proceed further with the legal background and the provisions that support the penalty imposed by CCI. So any inquiry can be made by CCI on the dominant position on the basis of its own accord or on receipt of an information from any person, consumer association or trade association. It can also initiate an inquiry on the basis of reference made by the central government, state government or statutory authority, right? In the cases that we are discussing right now, the informants were usually the consumer or consumer associations. The violation was abuse of dominant position. Now, when we say abuse of dominant position, Section 4, subsection 2 of the Competition Act provides various grounds on the basis of which it can be said that an entity has abused its dominant position. Let us understand each of these grounds and the relation and context of the present case of Google. Okay. So the first one is imposition of unfair or discriminatory condition or pricing. And Google was found to be violating both. So it required mandatory use of GPBS for paid apps and in-app billing as already mentioned, and also charged excessive service fee. One more discriminatory condition that Google imposed was that the excessive service fee of 30% was charged on all the apps, all the paid apps in the payment system in the Google listed on the Google Play, but the fees was not taken from YouTube for the purchases made from YouTube, which was again one of the alliances of Google. The another condition is limitation or restriction on the production of goods or provision of services or markets thereof, or the technical or scientific developments relating to such goods or services. And Google was found to create a negative impact on the improvement and development of in-app payment processing services since it denied market access to such payment processing services since it required mandatory usage of GPBS, okay, which is what the next ground is, denial of market access. Okay, the condition of pre-installation and prominent placement of GPay was also considered as a way to deny market access to other UPI payment service providers. Another ground is a contract involving supplementary obligations having no connection with the subject of such contracts. Google is not charged under this provision, and the use of dominant position in one relevant market to enter into or protect another relevant market. Now, to understand this, it is very important to understand the concept of relevant market and dominant position. So, let us just quickly go and understand that. So, relevant market can either be relevant product market or relevant geographic market. When I say relevant product market, the products or services in question are substitutable or interchangeable to each other on the basis of the characteristics, price, or intended use. For example, a Xiaomi mobile versus Realme mobile and Oppo mobile. These are interchangeable amongst each other. A person making a choice of whether to buy Realme or Redmi can easily interchange or substitute between them. But the same cannot be a case for a Xiaomi mobile and an Apple mobile, an iPhone. So there lies the difference. Next is the relevant geographic market. This constitutes the geographic location, the geographic boundaries within which the conditions of competition are distinctly homogeneous and distinguished from neighboring areas. Okay. On the basis of these, the following markets were considered as the relevant market for the instant case. First is the market of licensable operating system for smart mobile devices in India as against unlicensable operating system or operating system for desktop, laptops, etc. Other is the market for app stores for Android mobile OS in India, which we all know Play Store has dominance over any other app store. And next is the apps facilitating payment through UPI in India, in which market the dominant position of Google could not be proved. But again, if I move on to the previous slide, the dominant position in the licensable mobile operating system market was allegedly leveraged by Google to gain a dominant position on the UPI app market. Okay. So now let us also understand what dominant position means. So dominant position basically is the position of strength in relevant market. Strength as in the entity having a dominant position will not be affected, can operate independently of the competitive forces in the market and can rather affect its competitors or consumers in its favor. Okay. So that is how on the basis of various grounds and various conditions, various allegations, it was proved that Google had a dominant position in the licensable OS market and app stores, and Google has used its dominant position, has abused its dominant position to the favor of creating anti-competitive forces for which the CCI levied a fine, a penalty on Google. It also required Google to cease and desist, that is, to stop immediately the anti-competitive activities that Google is currently engaged into. That was it for today. Meet you in the next video. Thank you. Thank you was very